Hello, everybody.
This is the Butler County Probation Review docket of January 24, 2025. I'm David A. Rickey, District Judge. First case that I think I'm going to address on this docket is State of Kansas versus Mark Anthony Carter, case number 2023 CR 194. Amber Norris appears for the State of Kansas. Chris Pate is defense counsel. Mr. Carter, where are you currently located?
In Wichita.
Why are you not at the Judicial Center as you were ordered to be?
I just found out about the court today at lunchtime right at 12 o'clock. I did not know that the court date had been moved up, Your Honor.
Okay, and also Wichita to El Dorado is about 45 minutes tops.
But I called my attorney.
Mark, can I help out here, Your Honor? This might be my fault. I know he was arrested in Sedgwick County, bonded out. They gave him a court date in February, and then it was advanced to today. Mr. Carter called my office a couple hours ago. He told me he was going to have trouble getting out to El Dorado in time. I told him it was set for Zoom. I did not have anything in my file that showed he was ordered to personally appear at court. So I instructed him that Zoom would be acceptable, not being aware there was any prior order.
Almost every defendant on a warrant to show cause docket is ordered to be at the Judicial Center in El Dorado or Eureka or Howard, whatever our courthouse is where they're conducting the hearing. So it's a rare exception rather than the rule that they participate remotely. But Mr. Pate, I appreciate your statement. Let's proceed further. The allegations before the court is that on September 23 and October 23, 2024, the defendant submitted urine samples that tested positive for amphetamine, methamphetamine. Number two, the defendant failed to make any payments toward his court fees and restitution, current balance remaining $25,512.99. What are your client's intentions regarding these allegations, Mr. Pate?
Your Honor, while he does want to offer some explanation as to the violations, he's prepared to admit those and then proceed to disposition today.
Mr. Carter, you do have the right to a due process hearing where the state has the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, confront the state's witnesses unless good cause is shown, and among other lesser remedies, the court could consider just an outright revocation of your probation and ordering you to serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, I do.
And do you waive a hearing and stipulate and agree that you committed the positive urine sample and failure to pay violations as alleged?
Can I give an explanation
later?
Okay. Yeah, I mean, I did make payments to the Wichita area because they told me I had to pay these over here first whenever I was on, because it transferred my probation over to Sedgwick County. And I was told that I needed to pay that over here first. And then I'd been paying on it. And and the rest of it, I took medicine and it violated me. So there's no denying that, I guess.
Medicine?
Yes, sir. Sinus medicine. I've had all
medicine caused you to be positive for amphetamine and methamphetamine?
That's what they were telling me, because I quit taking the medicine and everything was cleared up. I submitted clean UAs all the way up until that point, and then after that, and then we figured out what it was when I went to the treatment. I even did the treatment education like I was requested to do, and I went through that successfully. I graduated that. I have the certificate for it. And they were telling me that the medicine would do that. And I stopped taking all the medicines and all my UAs have been clean since then.
All right. So are you admitting these violations or not?
Yeah, it's obvious that they were violated because I went back and read my court orders and stuff and the probation stuff. And I wasn't supposed to be able to take those medicines. And I didn't realize that at the time. I do apologize, but yeah, I did violate because of that.
The court finds that the defendant has waived hearing and stipulates and agrees that he's committed the violations as alleged in the warrant to show cause. Court finds these to be significant material violations of the terms and conditions of his probation. We'll now turn to disposition. Mr. Ketley, perhaps I'm going to start with you because you've got extensive experience in the supervision of various offenders. The allegation that mere over-the-counter medications, and I'm presuming these are over-the-counter medications, can cause a positive test that you take, that you administer for amphetamine and methamphetamine. Is there any precedent for that in your view?
Not that I'm aware of, Your Honor. I mean, there are some medicines like Ritalin or whatever will make you test positive for amphetamines, but not methamphetamines. The levels were over 10,000 nanograms for methamphetamines, and that's normally methamphetamines.
Obviously, I'm quite interested in the state's position on this case. Mr. Ketley, do you have any personal recommendations regarding an appropriate sanction or disposition here?
Well, I believe just based off the fact that he tested positive, and he has since completed treatment. So that is true that he has completed the treatment since then. The UA was back in October. I would get, this would be, well, it's his first violation, I'm guessing. So we probably, he'd have to serve some type of jail sanction, I would believe, Your Honor.
All right. Thank you, Mr. Ketley. I appreciate the information. Ms. Norris, your position here.
Your Honor, state would be recommending 2 days in the county jail as a sanction. I do believe we're at the stage where we need to begin the dip process. This is the first warrant to show cause. I do believe that the court would need to do an extension. He was initially placed on probation for 12 months with community corrections. And that was on January 2nd of 2024. So I do believe that he would need a 12-month extension from today's date. And Your Honor, I don't know what the defendant was referring to when he was saying something about payments over in Sedgwick County. I think he is courtesy supervised, at least to a certain extent. But he has, as far as I can tell, he has made 0 payments on this case. And obviously there's a significant amount of restitution. And it's my understanding that he basically told his probation officer that he wasn't going to pay it because his case was on appeal. And I would know for the court that the court did not allow for an appeal bond. So all orders are still the same and that the defendant needs to follow all of them. So like I said, I don't know what he's talking about with the payments. Mr. Ketley and I did have discussions a little bit about what's been going on with Mr. Carter. But he had actually even contacted me back in September, basically asking about the payments, and that, you know, he was ordered to pay $250 a month. And basically he was not making those payments. So obviously I think that's something that the court definitely needs to address at this hearing. And Your Honor, additional court-appointed attorney's fees and the bids application fee as Mr. Pate was reappointed for this hearing. Thank you.
Very well. I'm going to go back to Mr. Ketley. Is there some sort of fee that's charged by a courtesy supervision office, such as Sedgwick County's Community Corrections Department?
Yes, they charge $450, and it's just a fee for everybody that's on our program, whether they're a courtesy or a Sedgwick County case.
Is that something unique to Sedgwick County?
No, we have $125. And almost every district in the state of Kansas charges some type of supervision fee.
Right. So despite the fact that he was charged a supervision fee over here as part of his original sentencing, Sedgwick County charges him $450 over there?
Correct.
All right. Thank you for that information. Mr. Pate.
Your Honor, we would ask the court reinstate. I think an extension is appropriate in this case. I do think the maximum that the court could give under the state of the law with the first PV in this situation would be a quick dip. We are asking for a reinstatement. There were a couple positive drug tests. I don't think it's Mr. Carter's offered his explanation. I don't think I need to get into that anymore. He admitted to it. He entered into treatment. He successfully completed it. Every UA since then, my understanding, has been clean. So that issue appears to have been resolved. He does have employment at King of Freight right now. He reports he's making about $2,000 a month. He's got 4 kids at home. So money's pretty tight, but he understands he needs to start making payments. And I think the whole.
Well, Mr. Payton, I'll just interrupt you there. He was ordered to start making payments a year ago. And he understood then he had an obligation to be making payments. So what's different now? I mean, apparently he hasn't paid anything on the Butler County obligations for an entire calendar year. Would you agree?
Other than the restitution, it appears so, yes. It sounds like he had to pay that courtesy fee before anything would be applied to it. He's now employed. He's had a few months of employment. He understands he's going to need to get this paid off. I think it'd be beneficial to the victims to extend this and give them time to do that. We know it needs to be paid, Your Honor.
How much are your fees on this round of proceedings, Mr. Pate?
They'll be probably $200.
All right. Thank you for that information. All right, Mr. Carter, at this time, the court will address you personally and ask you if you have any statements that you wish to make in mitigation of punishment here.
Yes, Your Honor. I'd like to just say a few things that, I'm money is tight right now, and I've never, what the prosecutor was saying with my probation or whatever, my probation officer in Wichita, I've had 3 or 2 of them over here since the start of it. I've been switched from one to another, and then I'm back with Mr. Ketley now. But I never stated anything like I'm not going to pay it or any of that. I did say it would be nice not to have to pay it because it's on appeal, but I wasn't granted that by the court, and I have to pay these fines over here, but I just can't afford it at the moment, is what I was explaining to my probation officer. I don't think she understood my whole explanation of that. And then on the other note, I understand that the first probation violation, this is my very first one. And since then, I've straightened out everything that was in my system. It's no longer there. I did the recommendations. I'm working, and I'm barely paying the bills right now, but I got my feet in the door, and I got a good job, and it's going to work out. And the money I'll start making more money here shortly. It's just through these winter months. It's based on sales and hourly pay, and my hourly pay is about where I'm at each month at the moment at $12.50 an hour. But it should pan out to be more than that, so I could start making payments to them here. Hopefully by the end of this month, going into next month, I should be able to start making payments because I can only get a commission check once a month, and I haven't started getting commission yet. So that's about all I got to say, Your Honor.
Very well. For the violations that the court has found earlier, the court will order the defendants to serve 48 consecutive hours. In other words, a 2-day quick dip in the Butler County Jail starting at 6:00 p.m. this evening. So, Mr. Carter, you've got approximately 3 hours to get yourself to report to the Butler County Jail in El Dorado, Kansas, just east of town. I think you're familiar with the facility. To serve your 48 hours or 2-day quick dip, which the court has imposed. And then the court will reinstate the defendant's probation. All unsatisfied conditions remain to be satisfied. And the court will expect regular and consistent, in other words, monthly payments on the obligations that are owed in this case. Court will extend probation in this case for 1 calendar year. The original probation date was started January 2 of 2024. The court will extend probation at this juncture to January 2 of 2026, subject to further extension if necessary. Under the financial circumstances which currently exist, the court's not inclined to add additional amounts at this stage of the proceedings. So any bids, assessments, for this round will be waived. Ms. Norris, are you aware of anything further that needs to be addressed regarding the Mark Carter case at this time?
I don't believe so, Your Honor. Thank you.
Anything further from your perspective, Mr. Pate?
No, Your Honor.
All right, Mr. Carter, again, I'm sure you've heard all of the court's orders. Your probation's been extended after you served this 2-day quick dip in jail, starting at 6:00 p.m. this evening. And I'm going to direct the community corrections officer that if he doesn't report, as the court has ordered, to file another warrant to show cause. Any questions about that, Mr. Carter?
No, sir, Your Honor.
Very well. Then the Mark Anthony Carter matter will currently be in recess, and we'll move on to another matter.
I love you so much. Be safe, be well, sleep sweet, and much love.